All right, section 10, we're trucking on along, real estate contract law. We said already that the majority of what we do in the business bases around our contracts. My husband took pictures of me a couple of years ago and sent them off to this like puppet maker type guy and had a bobblehead made. So she's really funny. She has her own persona in our office. She's been caught in our advertising. She plays tricks on staff people when I'm not looking. I don't do it, but she definitely does. But I have a real life little bobblehead in my office, and she looks exactly like me, and I think it's the most random thing, but my husband thought it would be cool to make me a superhero. So I have a bobblehead, and she actually stands on a podium, and her podium says, "What does your contract say?" Because I guess that's what I'm known for. People walk into my office and say, well, I'm having this issue with my contract, and this buyer's doing this, and the seller's having issues. What do I need to do? My immediate answer is always, what does your contract say? Because the basis of all of our agreements is what's in writing. If it's not in writing, it's not enforceable. And I said earlier, if it's not in writing, it doesn't exist. Well, if it's not in writing, it might as well not. So we're going to talk about contracts and contract law and how that interplays in real life real estate. So if I run into you at Walmart and I shake your hand and say, you know, I need somebody to come and cut my grass tomorrow. I'll pay you $100 if you come and cut my grass tomorrow, and we shake hands on it. All right, I'll see you at 10 a.m. That work? Yep, 10 a.m. So you show up, you cut my grass, you get finished and say, hey Marlene, where's my money? And I say, we never had an agreement. I don't owe you anything. Could you sue me and force me to pay you the $100? Well, did we have an agreement? Yeah, we had an agreement. A handshake and a promise can be considered a contract because a contract is mutual promises. But would that contract, would that agreement be enforceable? Well, if it's in writing, we would have an enforceable agreement. So we're going to talk about contracts. We're going to talk about the creation of contracts. We're also going to talk about what I consider the status of contracts. So let's dive in. So first of all, contract validity and enforceability. The first thing that your book's going to tell you is the contract is considered a mutual promises based on a meeting of the minds to do or refrain from doing something. So a mutual meeting of the minds to do or not to do something. I can make a contract to do something, like you coming to cut my grass, or I can make an agreement to not do something, like certain deed restrictions might say that you're not able to open a bar on the corner beside the church. So a contract to not do something is what we call a forbearance agreement. I'm going to forbear my right to do something. So we can agree to do an action or agree to forbear and not do something. But legal status of contracts. Your book talks about some specific categories. One is valid. Valid is a good contract. Right now, as it stands, our agreement is a good, viable agreement. It's valid. The next one is void. Void, it was never good in the first place. It lacks one of the legal requirements to make a contract in the first place, so it would be void. The contract is not any good and it wouldn't be enforceable. And you'll read in your book about some different ways to know if a contract's void or not. The next one is voidable. Voidable. Your book says that a voidable offer is invalid if affirmed. Invalid. So a voidable contract would be something that could be made void. Quick example of that your book talks about, so I didn't make it up, but sometimes we talk about people that write contracts and make agreements without full meeting of the minds. Maybe they're under some type of duress. One of the ways to make a contract voidable would be if you signed an agreement while you were incapacitated, drunk, under the influence. So drunk people that write contracts would have a voidable agreement. Tomorrow, if you sober up and say, wow, I really made a mistake, I shouldn't have made that agreement. Now, if you're married, that's a whole different story. Don't get drunk and go to Vegas. That's a whole different session or something. But a voidable contract, say you go out looking at houses, your realtor shows you a whole bunch of houses, takes you out for drinks, you sign a contract. Tomorrow you wake up and you say, wait a minute, now that I'm of my right mind, I don't think I want to still be bound by that agreement. That could be voidable at the discretion of the incapacitated party. The same works for minors that make an agreement. Voidable at the minor's discretion. So valid, good. Void, no good. Voidable, we might be able to make it not good. So what are the criteria for a good contract? You got to have competent parties. There's a test question that's popped up that people ask me about that says that if someone is illiterate, they signed a contract, is that voidable? Well, whenever you see competent parties, that means mentally competent. They're of age. They haven't been deemed by the law to be mentally incompetent. You'd have to have legally competent parties, mutual agreement between them, some type of valuable consideration. I want to camp out there for 1 second because in a lot of jurisdictions there's an earnest money or a security deposit that's put up with a contract, and people mistake that for valuable consideration. Valuable consideration as a contract requirement could be love and affection. Just because I love you, or because of a gift, we're going to make this contract. But one of the essential requirements is valuable consideration. And when you start reading, don't get that mistaken for earnest money. Earnest money is common custom, but the valuable consideration can be anything of value offered to make sure that that deal has a little bit of skin in the game for it. Also have to have legal purpose, be voluntary, and act in good faith. So whenever you read through your contract requirements, make sure that you're camping out and know about those. So let's go on to contract creation. Contract creation. When you see the word contract, remember that is a mutual meeting of the minds. In everyday language, I'll say I'm working with a buyer. We like this house. We're going to write a contract. But whenever I sit down with my buyer to put his wishes into our legal documents, is that really a contract? No, because you don't have a mutual meeting of the minds yet. What is it that buyer is writing? The buyer's writing an offer. That buyer's offer would be sent over to the seller's agent on their behalf. That seller could either agree to all of those terms, and if they do, and everything is signed, sealed, and delivered, then we would have a contract. But what if the seller gets that and they don't like any of the terms? They cross a few things out and send it back. In essence, now our buyer's original offer doesn't exist. What we have now is a counter offer. Basically, the seller is now saying, no, buddy, I don't like your terms. Let me write my own and we'll start over. So every time an offer and counter offer go back and forth, the previous offer basically goes away and you're starting all over, and that seller is now the offeror and the buyer is the offeree. So the person giving the offer is the offeror, person receiving the offer is offeree, and that process goes back and forth until all of the terms are agreed upon, and that's when you have an actual contract. And as long as all of your valid essentials of a contract are in place, now we're good to go and we're moving along. So this chapter is also going to talk to you about how to terminate a contract. Legally terminating a contract without long-term repercussions is a little bit touchy. People always say, we're dealing with this in a transaction, can I cancel? Well, one thing that you have to be aware of in real estate is that we don't practice law. We're looking in this chapter at real estate contract law, but real estate agents are not licensed to practice law. So discernment of those contracts would be up to a legal professional. All we can do is make sure that we are filling the blanks in our pre-printed forms. We are following along in the process of trying to get that contract fulfilled, and then moving along with our agreements and representing our customers and clients the best of our ability using the forms that we're given. So if a contract does need to cancel or something goes wrong, you do have the basics in the body of this material to know a little bit about the discernment of how to legally cancel a contract, or what situations could legally cancel or terminate a contract. So whenever you get into this, I hope you enjoy one of your first kind of real life experiences, getting to know what it would be like to be involved in that offer counter offer form. There's a couple of good illustrations that walk you through the process of offers and counter offers, and then we'll take even a closer look at more contracts in later chapters. But remember, we're still building that foundation. So welcome to Real Estate Contract Law. Enjoy this session.